Welcome to the Family Law Frontline.
Welcome back to the Family Law Frontline with Fedor Kozlov. Fedor is the founding partner and chief litigator of the Law Office of Fedor Kozlov, PC. With over a decade of experience in Illinois family law, he handles high-stakes cases involving custody, property division, domestic violence, and complex divorces. I'm Leanne Lyon, and today we are talking about digital evidence in Illinois divorce and custody cases, including text messages, emails, and social media, and how courts decide what matters. It's good to see you again, Fedor.
Good to see you, Len.
Fedor, how often does digital evidence become a turning point in Illinois divorce or custody litigation?
I would say nowadays almost all the time. There were sometime about maybe 15 to 20 years ago when text messages, emails, things like that were extremely difficult to get into the evidence because you would have to go through some steps, introducing it, whether or not it's an original, things like that. These days, everything that people talk about, and sometimes, it doesn't even matter what they do, what they talk about is extremely important. It's all admissible in court. These days, I've seen judges not even requiring you to print it out or translate it or notarize it. All you can do is just show the telephone message to the judge right there in the courtroom. Especially it's important with the orders of protection. For example, if somebody sends somebody a threat or calling names, this kind of messages getting into right away so that any message is admissible.
So, what types of digital evidence show up most often in your cases? Text messages, emails, direct messages, deleted content, or location data?
Text messages are the number one. These are the champions because people text each other all the time. Text message, you have your phone with you at all times. And it's, people get emotional. And once something goes wrong, they send the text message right away. And it's the most valuable piece of evidence because this is the time when the person didn't have time to reflect, talk to somebody else, or do something, and sends this text message right away. Then the person thinks about it and probably changes his or her behavior and mind, but the text message is a text message. She's been already sent. So it's there. I should say two quick things. One, all this data usually introduced for the purposes not of the substance, but to impeach a person, caught them in a lie, things like that. That's number one. And number two, specifically for family law, we have two programs, Talking Parents and Family Wizard. So these are the programs when people have extremely difficult time to talk to each other, or there is a domestic violence, domestic abuse. These are the programs that ordered by the court for the people, for parties to use in order to talk to each other in regards to the children. And those messages are always admissible in court. You can save them, you can send it to the judge directly, and yeah, so those are programs designed specifically for people to communicate for the purposes of the courts.
So, that's a great point. You said that that is always admissible. How otherwise do Illinois courts determine whether digital evidence is authentic, admissible?
Well, usually it's through the testimony of a person, or it's pretty much admissible all the time. I see motions and petitions every single day with emails from attached as exhibits, because you have to remember that the evidence, if you want to introduce this evidence to court, a picture, things like that, you have to lay out a foundation. You have to put the witness on the stand who took this picture. Usually, it's a party. With motions, you can people attach in family law proceedings anything they think that is relevant, or sometimes not even relevant. But I always see all the time text messages attached to the pleadings. This is the message I received from him. This is my response. Even lawyers attach correspondence between them, between the law firms, in order to file motion to compel, let's say. So somebody sends somebody an email, and now there's a response, and he promised me to do this, but now he's not. He was Exhibit 1. So every time you send an email, remember that it can be used in court.
Can you walk us through a case where text messages or maybe social media posts significantly change the outcome of a custody or property dispute?
Of course. I just finished a case yesterday via settlement, instead of going through the court trial and procedures. And one of my friends is a Facebook. Uh, it's an extremely useful tool for discovery and evidence. Um, People still share on Facebook a lot of information. They don't even think about it, but
Mm.
they want to share with the world their joy, or achievements, or whatever they want to share. So the case I'm talking about that involved payment of maintenance from one party to another, and I represented the husband, and the terms of the marital settlement agreement. And law in Illinois in general is that you will pay maintenance until the other side starts living in the marriage like relationship with the other person. And the marriage like relationship includes not only intimate relationships, but travels together, dinners, um, you know, sharing the same household on a daily basis for routine things and stuff like that. And the opposing side was a mother who was receiving maintenance, and she denied her relationship with a different person. And throughout the whole proceedings, she was denying it, that she seen somebody on a marriage-like relationship. She admitted that she had a boyfriend, but having a boyfriend doesn't necessarily negate the maintenance. So, of course, on her Instagram and the Facebook, she shared all of her pictures of her travels with her daughters and his kids to different places. And travel is a huge thing in determining whether or not you have a marriage-like relationship, because that's exactly what couples do. They travel together, and especially in that case, they traveled with kids. So, what Facebook, interestingly enough, has a option where you can download your whole data, or you can specify from which time to which time. Uh, it's in the menu. You can have it, and you can subpoena it, or in this case that we had, we simply asked to produce it. So, and of course, once it was produced to us, it was clear that she was in a marriage-like relationship, and we settled the case.
So, what mistakes do people make when trying to use screenshots or forwarded messages in court without understanding evidentiary rules?
Well, it's hard to say, whether or not people make mistakes. Like, we all make mistakes in this regard, but we don't think that something bad, is going to happen, right? So, if you in the relationship, you want to share your love with this particular person to the whole world, that's what you're going to do. um, you don't think that somebody else or this person in the future will challenge something. So uh, in any picture and any message, even though if it's deleted, it um, leaves some kind of trace. So besides family law, very quickly, I also do some civil procedure and litigation, and I am involved in a case right now where I represent an employer. There was an employee. She claimed she was terminated for a wrong reason. and there's an email correspondence between them. So the she deleted this from her computer, but the computer still has that data. I'm not a technical person myself, and God bless those people who know how to do it. Fortunately, we have a company that knows how to do it. So all we had to do is get her computer, and we were able to get all of this information from the computer. But it leaves straight. Just because you deleted it, it's there.
So, how do courts handle deleted messages or altered content? And what role, in that case, do forensic experts sometimes play?
Forensic expert, very important people for these purposes. Again, not it's not their services usually sort of expensive, but it's kind of worth it. Especially at high stake cases when um, when spouse is trying to hide assets, or there's a petition for dissipation of marital assets, meaning that somebody is trying to hide the asset and move money, or close accounts and delete those accounts, things like that. So that forensic expert is very, very important. The way the court handles it, well, there has to be a chain of custody, of course. So, first of all, again, it's an expert. It's a battle of experts. Family law involves many different experts. So, forensic expert is one of them. It's usually retained forensic expert for the purposes of the rules. It's 213F3, and he or she would need to provide their resume, explain how many times they already testified in court, and then testify about the specific deleted data that they were able to obtain, how they preserved it, and why this data that this data was not in any way damaged or edited, or like this is exactly the data that they had. And if this evidence is admitted by the court, then just the fact that the person was trying to delete it is also it has negative implication that he or she is trying to hide something.
So, are there risks to accessing a spouse's or co parent's accounts without permission, even if somebody believes that they're covering up important information?
Well, yes and no. It's hard to say. So there are so many rules of Illinois civil procedure, like that prohibits recordings without consent, and videotaping without consent, and of course it prohibits access to somebody else's computer. But here's the thing: so it all depends on the timing. Uh, of course, if the case is already filed and if people officially in the battle, in the divorce proceedings, everything has to go through lawyers to be admitted. Because if you obtain some kind of evidence without proper procedure, simply it might not be admitted to court. Now, if you obtained, what happens a lot, if obtain some piece of evidence and give it to your lawyer, but then you're not using this specific piece of evidence in your case, but later you can discover something else, that part of the evidence can be admitted. But if you keep your computer out in public, laptop, and you still married, uh, and the best case for I don't know if you ever heard about the staircase murder or lawsuit. That was a long time ago, I think in 2003, if I'm not mistaken, in South Carolina, when a man was accused of murdering his wife, and allegedly he murdered her for because she found out some pornographic pictures on his computer. And there was a lot of discussion in that case if that's admissible evidence. And at the end of the day, the judge ruled it was admissible evidence, even though it was his computer in his office. And the wife discovered it. They lived in the same household, and she went to his computer without his permission. This is how he found out about that, about those pictures that led to the argument that led to her death. So such evidence, if discovered in your household and it was open and you were married, um, very well this computer can be a marital property and it's admissible in court.
Yeah, fascinating. So, as we wrap up here, for somebody currently going through a divorce or custody dispute, how should they think about their own digital footprint while the case is pending?
While the case is pending, well, it depends on the circumstance, to be honest. So in like I said so many times, I think throughout our podcast, the fact is always a fact. You cannot really lie about facts. If you lie about a fact, uh, it's really bad. You can always explain it, but don't lie about it. I usually, for example, when I go through discovery and I go through depositions or things like that, I usually ask questions to which I already know the answers. So I welcome a lie. And that's what the depositions are made for. The depositions are not made for, accuse somebody of doing something. Depositions is for to collect information and lock a person on a lie because you're doing it under oath. So if you already have something on your computer, if you have footprints on your computer, if you have data on your computer, if that's discoverable and has to be produced by the other side. If you have a good attorney, that attorney can probably file motion to quash or motion to quash any discovery request based on relevance and things like that. But from my experience, especially in family law cases, pretty much everything is discoverable and pretty much everything is relevant. So if somebody is asking for your computer, Illinois is a no fault state, so we don't have to prove a fault. We don't have to prove that somebody was cheating or abusing drugs or alcohol, things like that. So if you're trying to, intimidate somebody, probably motion to quash such evidence would be granted. But if you're just trying to find out someone's bank accounts, or for example, somebody opened a bank account and never disclosed to his wife, and we have many clients that they went through the course of their marriage and they always had separate bank accounts. So in that case, it's discoverable and you just have to produce it, really. I think the more you hide it, the more negative assumptions can be incurred against you. So my only advice: talk to your lawyer and see if a motion to quash or motion to compel is necessary in a particular case.
Well, it's a fascinating topic. Thank you for diving into it with us today. And that is it for today's episode of the Family Law Frontline. If you are navigating a divorce or custody case and you're concerned about how your digital evidence could affect the outcome, visit lawyer-il.com to connect with Fedor Kozlov and his team. Thanks for listening, and remember to like, subscribe, and leave a review, or even forward this episode to someone who needs to hear it if you found this episode especially helpful. Thank you, Fedor.
Thank you, Aaron.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.